my friend Mr. Dwivedi appeared on behalf of the state of Madhya Pradesh. But like me, my lord, he is from the great state, may I say, of Uttar Pradesh. And my lord may see what the state of Uttar Pradesh did, following my lord's directions in Nalsa. The 7th State Law Commission, my lord, in Uttar Pradesh, entirely relying on my lord's directions in Nalsa, finds that they have been directed to improve the conditions of transgender persons and specifically take up the issue, my lord, of laws of inheritance. So, what do they say, my lord? The Hindu Succession Act as well as the Indian Succession Act are central legislations, and although the state government has power to amend these legislations with the concurrence of the central government, this has a long procedure. Therefore, this commission has confined its study to the right of succession in agricultural property as well as the grant of lease regarding Abadi lands in Uttar Pradesh. And what, my lord, has the great state of Uttar Pradesh, for which I am a proud citizen, my lord, of Allahabad, has it held? They amend the Uttar Pradesh Revenue Code in 2020, and what do they introduce? The family in relation to a tenure holder means himself or herself and his wife or her husband or third gender spouse. This is the current state of the law in UP, my lord. As the case may be, other than a judicially separated wife or husband or third gender spouse, minor sons, minor daughters, other than married daughters, and third gender minor issue. So not only, my lords, following your lordship's declaration and directions in Nalsa, not only do state legislatures now recognize third gender children as successors to the estate, they also recognize the possibility of third gender marriage, of marriage of third gender persons, as the statute calls it, and in fact, even situations where there may be a judicial separation of such persons. And thereafter, my lord, they are incorporated into the degrees of succession as the land revenue codes imagine, my lord. So, my lord, my submission is that your lordships open the door. Your lordships tell us as a country where the law stands and where our constitutional values stand. And then, my lords, a social debate happens, a legislative debate happens. And, my lords, we as a country, we adhere to the constitution. We bring ourselves, we rise, my lord, to the level of the constitution. The last submission I'll make is this. Your lordships have in effect been told that because there's a vast problem of statutory interpretation before, my lords, your lordships should not touch the constitutional issue. That your lordships will be so troubled by a question of statutory interpretation, however frequently it may arise, my lord, and however many statutes it may arise. But if I may just submit to your lordships, if my lords take yourselves back, perhaps 15 years or maybe even more, when my lords sat as single judges in the high courts, and perhaps, my lord, a young Justice Narasimha then appears before my lords, and my lords, these issues come up, my lords, in MAT FCs, in MAT appeals, in FAOs. And they are questions, my lords, then of statutory interpretation. They arise, my lord, in individual cases relating to individuals who come before my lords in many combinations, as my Lord Justice Bhatt has put to us throughout the course of these proceedings. My lords, look at the facts. And my lords, this is why, my lords, we are not running away from a question of statutory interpretation. We are not saying that these questions are insurmountable. It was asked in this court, my lord, who will be the father or who will be the mother? My lords will look at the statute, as my lords would have done 15, 18 years ago. Look to the statute, look to the law and the declarations laid down by the Honorable Supreme Court, and will find solutions for the persons who come before them. Because, my lord, Parliament can choose when it decides to address an issue. Parliament can choose, there may be a social problem, and Parliament can turn a blind eye. But, my lords, your lordships, the high courts, and the courts below, the family courts, the civil courts, they do not have that luxury, my lords. When persons raise a list before your lordships, when they come with a cause of action, the courts have to address those questions, and they have already been so doing. There are cases going back to the 1990s, my lord, where transgender persons have come raising questions, my lord, do we fall under the HSA, for example? And the courts, in one occasion, say, no, your customary law applies to you. In another case, my lord, again involving transgender persons, the courts say, no, Muslim law applies to you. So, my lords, our only submission is this. Today, what is the reference before your lordships? Your Lordships limited the reference to the Special Marriage Act. We are not going beyond that act, whether it is in questions of the Hindu Marriage Act, my lord, or on questions of other statutes. Because that was not the nature of the reference. But it's not, my lord, that these questions are in any way unanswerable. So let me end, my lord, with this. It fell from my Lord Justice Bhatt, for example, that suppose there are two Hindu women who are a couple, and one of them passes intestate. So let's take the case, my lord, of a female Hindu passing intestate. How would my lords then interpret the HSA? And my lord, it's been argued on this side that some have argued that section 21A ought not to apply. Some have argued, and I have argued, that 21A ought to apply. My note deals with that in detail. I won't trouble your lordship with it anymore. But let's suppose, my lord, that we come to this point that there's a question of whether the Hindu Succession Act applies, my lord, to, my lord, a female Hindu who dies intestate. What does 15 say, my lord? The property of a female Hindu dying intestate devolves according to rules set out in section 16. Firstly, upon sons and daughters, including the children of any predeceased son or daughter. Secondly, upon the heirs of the husband. Thirdly, upon the father and mother. Fourthly, so and so. So what happens here, my lord? And I'll just end with this. My lords will deal with the question of a female Hindu, my lord, who has a spouse, and therefore there will be a question at that stage of does this act now envisage that the spouse of a female Hindu is covered here, but her husband, but the children, my lord, will be covered. And the issue, my lord, as to how these statutes will be interpreted, what will be the interpretation, my lord, is one to be left to those courts to decide. I'm highly obliged, my lord.
Thank you.
I'm highly obliged.